This is Jeff Burkhardt. I'm the director of the Texas Indigent Defense Commission. We're glad you're here. This is the online courts web series co-hosted by TCDLA and TIDC. Today we have David Slayton, who is the director of the Office of Court Administration. He'll be talking about online courts, why and how Texas courts went online, as well as how it's gone so far. And then we have James McDermott, who is the Chief Public Defender for Far West Texas. So he's going to be talking about his experience as an early adopter of online courts, his use of Zoom, Docusign, and video conferencing to talk to his clients. So we'll get started in just about another 5 minutes. Thanks. Hey, for the folks just joining us, we'll get started in just another minute. This is Jeff Burkhardt. I'm the director of the Texas Indigent Defense Commission, and this is the webinar about online courts and early adopters. We've got David Slayton, who's the director of the Office of Court Administration. He'll be talking about why and how Texas courts have gone online and how it's gone so far. And we have James McDermott, who is the Chief Public Defender for Far West Texas. He'll be talking about his experience as an early adopter in his use of Zoom, Docusign, and video conferencing to talk to his clients. So we'll get started in just another minute. Thanks. Good afternoon, everyone. We're going to go ahead and get started. My name is Jeff Burkhart. I'm the Executive Director of the Texas Indigent Defense Commission. This is the online courts web series that's hosted by TCDLA and TIDC. We're very happy you're here with us today. We know this has been a tough time for a lot of attorneys throughout Texas, and COVID-19 is affecting a lot of family and friends for a lot of us. And in addition to that, we know that it's a big transition to move to online courts. Some folks have been using online courts for a while, and other folks are new to it. So TIDC was very happy to partner with TCDLA to bring you this series. Today we have early adopters for online courts. We've got two folks. The first is David Slayton. David is the Director of the Office of Court Administration, and he's going to talk about how and why Texas courts went online and how it's going so far. We also have James McDermott. James is the Chief Public Defender for Far West Texas. He's going to be talking about his experience as one of the early adopters for online courts, including his use of Zoom, Docusign, and video conferencing to talk to his clients. So we're going to get to them in just a minute. First, a few housekeeping issues. So we do partner with TCDLA on this. There will be CLE for this, and CLE will be offered via TCDLA. They're going to follow up with you online. So be sure you stay on for the whole thing. They do track how much time you spend on the webinar. And at the end of it, they will email you afterward to follow up about CLE. So please make sure that you show up for the whole thing. Otherwise, you won't receive CLE. And also, although we love having David here, we love having James here, just to let you know at the outset that the views expressed by David or James don't necessarily reflect TCDLA or TIDC. TCDLA and TIDC just bring this as information to you all as defense attorneys, something we think that might be helpful. But again, we're not necessarily endorsing the views of either David or James. Also, if you haven't seen the previous webinars, we have one, this past webinar, we have one called Online Courts for Defense Attorneys. This one is a great place to start. This was hosted by Kathleen Casey-Gomez. And really, this is just how do you use Zoom for online courts? Even if you've used Zoom before for conferencing purposes, using it for online courts is a little bit different. So we really encourage you to start with that. After that, last week, we had Online Courts in the Law with Professor Jennifer Lauren from the University of Texas. And that was a great one, also very well attended. So you see the links in front of you. We'll be sure to include those in the chat box as well, so you have access to both of those. We also have some upcoming webinars. Next week, we have tools you need for working virtually in the new age of online courts. This is with Grant Shiner. Grant is the incoming president of TCDLA. After that, we have Padilla in the Age of Online Courts, and that is hosted by Julie Wimmer, who launched My Padilla. And then finally, we have Online Courts 1 month in, and that's going to be Kathleen Casey-Gomez again, and she'll be joined with Casey Kennedy, who is the head of IT for the Office of Court Administration. So those are the upcoming webinars. Please keep an eye out for those. Every webinar is going to be Thursday at noon, so we're going to keep that consistent every Thursday at noon. As I mentioned, CLE will be offered for this. Your questions, if you could use the Q&A function down below, that's how we're going to handle questions today. And I'll be happy to moderate those questions. David's going to present for about 15 minutes. James will speak for about 30. And after that, we're going to leave a little bit of time for questions, and I'll be happy to moderate those. So be sure to include all of your questions in the Q&A box. And I think that's it. David, James, Stacy, Kathleen, anything else before we start? Okay.
Oh, ready.
David, thanks for being here today. I'll turn it over to you.
Thank you, Jeff, and thank you to TCDLA and TIDC for hosting these important webinars and for the invitation for me to provide a little bit of an update on how we got where we're at from the court's perspective and how things are going, where we may be headed in the future. I'm happy to provide you a little bit of an update. Some of you may be unfamiliar with the Office of Court Administration, but the office is a judicial branch agency. We are an independent judicial branch agency, but we work very closely with the Supreme Court and the Court of Criminal Appeals to assist in operation and administration of all the courts in Texas, from the municipal court level up to the two high courts. And so one of the main things that we are responsible for providing by law and by the budget writers is we're responsible for providing technology to the courts. And so obviously when we start thinking about the pandemic that we're going through right now, clearly this is an area where we began to look at what could we do to assist. So before we move on to a slide that I'll have in a second for you to give you a little bit of an update, I wanted to kind of give you a little bit of background of how we got where we're at. One of the things that we did was when the governor's office, when the governor and the state began to think about how the state of Texas would respond, he put together a number of state agencies and other entities that were that they designated as directly responsible for planning the response of the state of Texas to the pandemic. And the Office of Court Administration was one of those organizations, the agencies that was identified. And so we were involved from the very beginning of the state's planning. So as we began to hear about the fact that the pandemic was likely to have a significant impact in our state, we began to think about how would the courts operate in this new environment. Both the Court of Criminal Appeals and Presiding Judge Keller, as well as the Supreme Court of Texas and Chief Justice Hecht, we had conversations with those folks and said, you know, what do we want to do? And the options obviously were to just shut down, only do emergency matters, but nothing else. Or maybe even not even sure we could even do emergency matters if the situation got really dire. And so we were trying to figure out how we would operate in this new environment. And both of the high courts and the Presiding Judge Keller and Chief Justice Hecht really said that from their perspective, it was important during this time of a lot of instability and uncertainty for the judicial branch to be one that could be as stable and certain as we could be. All of you know from your role as many of you as practicing attorneys is that's what the courts are here for, is to be able to deal with situations as they arise. And just because we're in the midst of a pandemic doesn't mean that those issues stop. So we began to look at what types of things could we do. And really court proceedings really separate into two areas, what we would define as essential and non-essential hearings. And when we began to look at this, we thought, well, there are obviously essential things we have to do. So from your perspective, we have to do the 1517 magistration first appearance, whatever you want to call it, the first time when people get arrested and they go before a judge. Obviously, that's a critical, essential proceeding that really there was no way to stop doing that. There are, CPS child removal cases where that emergency hearing has to happen very quickly, and then other hearings in the future. Those are types of emergency matters that we might have to have, or a mental health hearing. You could go through and list those. Everything else that's not an emergency or non-essential matter, of course, would be non-essential. So one of the thoughts was, well, let's just do essential or emergency matters, but put everything else off. And we quickly began to think about the fact that if we were to do that, many of the proceedings that we typically have would be non-essential. And so in effect, most people's proceedings would be delayed, perhaps months at this point when we were looking at this. And so we really all came together and said, we need to find a way that the courts continue to operate as close to fully functional as we could. Obviously, there's lots of challenges with that. And one of the first ones that came up, which is how do we do it? And so we began to look at the various tools that are out there. And there were a couple of kind of key things that we felt were important. One is it had to be easy for everyone to use, both the internal users and the external users, so that people could actually gain access, and it wasn't having to learn some specific system that was really complicated. So we looked for a platform that would be easy. The second thing really important from our perspective, and especially when we're looking at criminal proceedings, as many of you are involved with, is making sure the public had the ability to observe the proceedings. All of you know the Sixth Amendment to the United States Constitution requires a public trial in criminal cases. The Texas Constitution has a similar provision. But in addition, there are First Amendment rights under the US Constitution that allows the public and the press to have access to court proceedings. And so we needed a tool that would allow us to continue to provide to the public an ability to observe court proceedings, even if the court proceedings were being held in a county where there was a stay-at-home order, where people could not technically go to the courthouse to observe. And so we looked for a way to be able to provide the public with that access. And then lastly, we wanted to make sure there were a couple of other key features, one of which was being able to provide to you all as attorneys the ability to confer in private with your client in a way that no one else could observe. It couldn't be recorded, all the issues that come up in that area. And so ultimately we settled upon the Zoom product, which I think many of you are getting familiar with or are familiar with. So from there, the question became, now what? So this was in early March, late February, early March. And so whenever the governor declared a state of disaster in Texas, we just had a few cases at that time, you might recall, the Supreme Court and the Court of Criminal Appeals jumped in immediately within an hour or two of that emergency declaration, and they entered a couple of orders. Stacy or Jeff, whoever's controlling, can you go to the next page? So here's just the first emergency order was entered on March 13th, the same day the governor declared a state of disaster. And under the current statutes, when a state of disaster is entered, the Supreme Court gains additional authority to suspend certain procedures and procedural requirements and deadlines and other things, not constitutional provisions, but the procedural and statutory deadlines and things, rules. And so the Supreme Court and the Court of Criminal Appeals jointly issued an order which did a couple of really important things. The first was it allowed for remote proceedings through video conferencing, teleconferencing, telephone, really all of the remote technologies. The court's order said that basically every court in Texas, whether it be civil or criminal, could use that technology, and that the parties, they didn't have to get the parties' consent to do it. And so really the courts could then say, no, you're going to participate in this hearing remotely using this type of technology. So that was a big thing. They also, as one of the portions of this order, allowed the judges to handle that hearing remotely from the courthouse. This was actually amended by the third emergency order slightly to allow it to be done even out of the county of venue, as long as the parties had notice of the proceeding and the ability to participate, and the public had the ability to participate and notice of the proceedings. And so that order was entered on March 13th. Within a few days of that, we began to test with judges around the state. We had about 20 judges we first worked with, all the way from municipal court judges to appellate court judges, and said, can you test out Zoom? Because that's what we were looking at using at the time. And immediately the judges began to say, we think this is a great tool that we can use. Obviously, there were lots of questions and how we're going to do this and how we're going to do that, but we quickly began to put those together. And within about a week, we had procured, actually within a matter of days, had procured licenses available to every judge in the state, from the municipal court level to the Supreme Court and Court of Criminal Appeals. So we began to provide those, began to provide training to judges, and judges began operations. So you see on the slide here in front of you, and I've actually got a little bit updated numbers even since this, but in the first 10 days of the courts in the state using Zoom to do proceedings, there were over 1,100 users of the court of that. Those users would be judges, because we issue one license per court. There were over 3,500 hearings held during that time frame, and there were over 27,000 participants. This information is about 2 days old. Let me give you the even newer information. We've held now, as of noon today, 4,500 separate proceedings. And when I say proceedings, that could mean as many as 51 cases on a single proceeding. So we're talking thousands, maybe well over 10,000 different hearings held this way. The courts have logged almost 20,000 hours of meetings on Zoom for hearings, and there have been over 43,000 people participate in these hearings. So you can see it's pretty robust, being spread across the state. You may be aware that we have posted on our website, you get the direct link here, but you can just go to txcourts.gov, and it's on our homepage, a link right at the top. But we've posted a lot of information on there about, one, how to get to sort of tips for both judges and others, some tutorial videos out there for how to use Zoom. We also have YouTube channels for about just over 500 of the courts are posted on our website, so you can go and actually watch live those proceedings. A couple of things in the few minutes I have remaining here before I turn it over to James is a couple of things were important from the criminal perspective, and I want to make sure that you all know that we have been and we are thinking about these things. We trained the judges and reminded them that this is still a courtroom, and I'd like to remind you all of that. This is still a courtroom. Just because it's online doesn't mean we're operating in some new environment. So we should all treat it that way. And we reminded the judges that we thought that was really important. We reminded them that the constitutional requirements that existed for courts in the physical realm have not changed. So the various constitutional provisions in both the U.S. Constitution and Texas Constitution, none of those have been suspended. And actually, as you know, the courts don't have the ability in the disaster to suspend those constitutional requirements, and they still exist. So really, all of those things that you all would be important to you, from the right to a public trial, the right to confront witnesses, all of those type of things are still there and still need to be taken into account as they use their online virtual courtroom to do that. Obviously, in that same regard, all due process rights remain. So we need to make sure that we ensure the rights of the defendant or other parties in cases, and that we take that into account. One piece of information was that the two high courts in their first emergency order allowed remote participation by everyone except for jury trials for jurors. So obviously, at least at this point, the courts have not opened up remote jury trials, and I'm not aware of any effort to do that right now or in the future. You can imagine there's a lot of complications with that. And then we reminded everybody, and this is a good reminder for you all too, which is this is a new process. It's a learning process. We're probably not going to get it right all the time from a technology perspective. And so we just reminded them to start slow, test it out with some hearings, and move forward and be patient with everyone that's involved. So that's really kind of where we've been. A couple of things where we're headed. Obviously, as long as the pandemic is proceeding, we'll be in this environment. We have advised judges that they can't have any in-person hearings that are not essential, and they can't have in-person hearings if it's possible to do them remotely. So if there's any capability of doing the hearing remotely, even if it's an essential matter, it can't be done in person. It's got to be done through the remote technology. The exceptions to that are obviously if they can't do it remotely, or if they can't do it remotely, then they can do it, but only if they have less than 10 people in the courtroom, or 10 or less people in the courtroom, and they ensure social distancing. The only exception to that are grand jury proceedings, which can occur because the law requires them to have more than 10, and they have to be socially distanced as part of that. That's really where we're at. I saw someone asked a question, so I'm just going to quickly hit it, and then I'll turn it over to James, which is the privacy issues. And I know many of you are hearing about this, and in fact, we're putting out guidance to judges today on this issue. If you're reading the press, you're hearing about Zoom bombing, you're hearing about security and privacy issues and different things with Zoom. First of all, let me remind you that anytime we're on the internet, security and privacy are big concerns that we all should be aware of. And so when we began to look at this as a tool, we looked at that issue before we started giving accounts to judges. Is this tool such that we can provide the security and privacy? And what I will tell you is that we still today, as of this moment, are very confident in the fact that Zoom, for us, the way we're using it, has a security and privacy protections in place. A lot of the issues that you'll read about, I can go through every one of them, but I won't today, but every single issue that you've read about, a lot of those were based upon settings in free accounts where the additional security and privacy features were not available. With our account, whether you have a free account on your side, when you join our account, all those privacy and security settings pop in. There's also about probably 200 separate privacy settings in the Zoom administrator account. And we went through every single one of those and really thought through what is the appropriate setting from a privacy and security standpoint. And those settings are available in all of our judges' accounts. And so, at least as of right now, things can always change, but as of right now, none of the privacy and security issues that are out there have caused us a great deal of concern with the fact that we're able to control that through our settings. Just because someone mentioned Zoom bombing, I'll talk about that specific one and let you know what our privacy and security settings are with that. One is, so Zoom bombing is when someone just comes into the meeting unexpected because they got the meeting ID number, and then they become a participant in the meeting, they start broadcasting inappropriate content or doing terrible things that we might expect someone with malicious intentions to do. And so we did two things. One is we created the waiting room, which basically you can't get into a court proceeding through Zoom with our account unless someone admits you. We advise the judges and the court staff, don't admit people that you're not expecting. So if someone shows up and you don't know who it is, don't admit them. Obviously, you could talk to the parties and the attorneys and others and say, hey, do you have someone coming that's a witness? So obviously those type of things are there. The second thing is we advise our judges not to use the same meeting ID over and over again because someone could ultimately get it, and to carefully guard those meeting ID numbers so they don't get out. So that's just one example. There are many examples of the privacy and security settings. And again, I said we'll be putting those out later today, and the guidance will be posted on our website, so you'll be able to see that. But we believe as of right now that we're pretty confident in the settings that we've set up to provide that security and privacy. So I'll turn it back over to Jeff, and I'll be hanging around for some questions at the end. Thank you all so much.
Well, thank you, David. Appreciate it. We'll turn now to James McDermott, the Chief Public Defender for Far West Texas.
Hi, I'm James McDermott, and Stacey, if we can go to my first slide. This is what my first reaction was when I was hearing about online courts. I think a lot of people, their first reaction was, oh my God, every day I'm in court, my client's gonna say something stupid, and now how do I control that? And I think that's a real concern, and that's, I think, a lot of where a lot of our fears come from, is that we just don't control the situation, and we're used to controlling what happens in the courtroom when we're actually there, and we can grab somebody's arm, or we can interrupt the judge, or we can, do the things that we normally do to sort of exercise the control we can, and we can't do that in Zoom, and that causes a lot of fear. I'm going to talk a little bit about that this afternoon, but that's just one point of a large number of things that we need to be thinking about and the practical issues that come up. And very briefly, Far West Texas Regional Public Defender, we're out here in Big Bend country. We cover 5 counties. The geographic range means that if you drive from one end of my county to another, it's maybe about 6.5 hours if you drive from one end of my jurisdiction to the other. This has been a problem for many, many of our clients, witnesses, people who want to come to court, people who have to come to court. And I think that if we can go to the next slide, one of the things that's important is virtual hearings are going to happen. The change that has happened here in the last month is not going to go away. It's going to change fundamentally how we're doing court and the kinds of options and tools we've got available. We have a choice as defense lawyers. We can obstruct, and we can say, we're going to try and object to everything that can come up. We're going to not do anything until we've got all the answers. Or we can try and take control of the situation and be participants in shaping what the future is of how these courts can work and what the limits are. We have an opportunity right now. And if we take ourselves out of the conversation, if we are obstructionist entirely, then we don't get to set where the boundaries are. We don't get to be part of the conversation about what the future looks like. And I'd really encourage everybody to think about what are the ways we can participate, what are the ways that this can work, and figure out where those appropriate boundaries are and police and enforce those boundaries instead of just starting off saying that this is just not going to work. And I know a lot of us we have a knee-jerk reaction. This is new. It's not the way we've done it before. But let's try it. And as David said, it's not going to be perfect, but let's try. I also want to address an argument that has been coming up in a lot of circles that I'm in about whether requiring clients to use this technology is unconstitutional tax. It requires people to get access either through a smartphone or through an internet line. And it is a cost. Where I live out here, for many of our clients who might be transient from outside the area, for some of our clients, I would say almost 50%, they have to travel from out of our jurisdiction to get here. To come to court each time costs them probably $1,000 to $1,500 each. They have to get transportation, hotel rooms, figure out how to get to court. For those of you in cities or suburban areas, there are still hidden costs for your clients having to come to court. There's transportation, there's daycare, there is parking, there is missing work. Those costs are all embedded. We don't talk about it as much because we don't see it, because we're getting paid to be at court. We are either getting paid for our parking and transportation, or we're deducting it or using it as a business expense. And so we don't see it as much. So we don't see how that affects our clients. This is an opportunity in my mind right now to really make the court system, the justice system, more affordable or more accessible to many of our clients for the things that they don't actually need to be in the courtroom for. And I'd really encourage y'all, as you look at costs and how the burden is coming on your clients, you do spend time with your clients trying to tell them, you do need to come to court. You do need to figure out how to get there. You do need to figure out your daycare. But remember, this is the same conversation that maybe is a great benefit to your client. And consider that to engage in this is an idea that there are many, many ways this can benefit your client. I'm going to talk about 3 areas now practically. In a very first sense, how are we doing this where I live? The practical problems that have come up. And then sort of the problems that I say are defining the outer limits, where I might balk or have objections, or the answers to me are really unknown, and things that we might be thinking about. And next slide, please. I just have to say that in the course, this, as Jeff said at the beginning, I'm going to be talking about several commercial products. I've received no money or compensation for any of the opinions that I've got. And I just want y'all to know this is purely based on my experience. I don't know everything that's out there. I just know what I have used, and I'm just going to try and give you the benefit of that experience. All right, moving on. How this gets done. As Jeff said 2 weeks ago, Kathleen went through all the mechanics of Zoom. I think that you should really, if you're not familiar with it or you've not watched that talk, you should start there. I'm not going to waste your time. I'm just going to go through a few highlights. One, for you and for your client, make sure that you're using the Zoom app and not the web browser version. There are several functions in Zoom that are not available right now or have not been available on the web browser. I'm going to cover a few of those in a second. But the whole thing works more smoothly if you download the Zoom app and use the Zoom app. When I go into the courtroom right now, I enter in through a waiting room. So the judge has us wait until he calls our case. We generally are not available to talk to the judge. We're just there in a holding pattern. It's important when you talk to your client to make sure they realize that if they're in the waiting room, that doesn't mean that nothing's happening. It's just as if they're in the courtroom, waiting in the gallery. When the judge calls a case, usually the judge or the court coordinator will control who's in the waiting room, who has access to be able to participate. When you get into the room, there are these breakout rooms. And if you're not familiar with those, if you need to have a private conversation separate from the whole group, you don't have to do that over your phone or outside of the Zoom app. The judge, and usually the judge is coordinating the process, the judge can put the participants in a breakout room. In that room, you will see anybody who comes in. Only people who come in can see what is or hear what's going on in the breakout room. You're talking to your client and maybe your co-counsel. I think that the way it's set up right now, the meeting moderator, who's usually the judge, would have access. Now, you would have to trust that that judge is not coming in. My judge has been very clear about how this works. It is the same as if you're in the courthouse. You're in the courthouse, you find a meeting room, you find the jury room, you go talk to your client. This is the same process. Is it 100% secure? No, the judge can come in, but in the same way in the courthouse, everything that you do in the courthouse and every communication you have in the courthouse is also not 100% secure. You have to figure out the level of comfort that you've got, and know that generally when somebody comes in the breakout room, you will be aware. The other thing to know about the breakout room is the judge can forcibly remove you from it and bring you back into the main meeting room. Now that is a little frustrating because it's different from when we're in the courthouse, when the judge summons you back and you can kind of drag your feet and try and finish up what you're doing. The judge can give you a time limit and it will force you back to the main meeting room. And just be aware of that. Usually it will give you a 1-minute warning and a countdown at the top of the screen. We have done language interpretation in Zoom. I've done several sessions with my judge out here. That's Roy Ferguson. It actually, in my mind, has worked a lot better than in-person interpretation because the volume for the person who is speaking the foreign language gets reduced. You can still hear it if you're listening closely. but the volume for the interpreter will be increased so that you're really only hearing, for the most part, the interpreter. I'm sure we've all had that experience where your client has disagreed with what the interpreter is saying, or is trying to talk over because they do speak some English. And that problem can really be minimized in this system where the interpreter becomes the main person speaking. And I've found that to be really useful. One note for both breakout rooms and interpretation, they do not work, again, if you're using the web browser version of Zoom. The last time I tested this out, it only worked in the Zoom app. And that's another really important reason to only be using the Zoom app and not the web browser. You need to make sure your clients are aware of that before you start the meeting so that they download the Zoom app and use that. Otherwise, these functions will not be available to them. Next slide, or next line. Your judge or court coordinator should be sending you a unique meeting code to invite you to the hearing. What's really important is that you do not share that outside of you and your client, and you need to make sure your client does not share that to other people. That is the easiest way for uninvited people to start to show up. Again, the judge does have control through making everybody wait in the waiting room. But really the meeting code should only be used for the people who are essential for the hearing. And try and make sure that you're aware of that, and don't send that out in a blast email to your friends or to everybody involved in the case. Just keep that to the people who are essential for the meeting. Next slide. Preparing the client. I think this is the real work that we have to do that is new. You are already used to preparing your client to go to court. You're already telling them how to dress, what to say, where to sit, when to come up to the bench. This is just a new way of doing it. And there's a lot of things that you may not think about until you're in the middle of it. I have done a few of these hearings, and there are a few that I've not thought of until I was in the middle of it and maybe doing it wrong. So I just want to give you the quick update. First, as I've said before, make sure your client downloads the app. You may in fact want to set up a meeting with your client before the hearing if they have some difficulty understanding, to do a dry run with them. It can help make them feel more confident if they're not used to using online technology like this. My court will only send the meeting invitation to the lawyers. Will not send them to the defendants. So that is, make sure that your client has an email address so you can forward the email with the invitation to your client. And that is the way that they will get into the courtroom. They can download the app for free. They can always get a free email account if they don't have one. Make sure, and you might want to just do a dry run of it. Often when you come into the courtroom, it may not be clear that the video is on or off. You're going to want to make sure you've looked over the functions down at the bottom, including the mute and unmute. Now, the judge usually has the ability to mute or unmute from his or her position. And so if your client really can't figure that out, often that can happen by the judge. Just also be aware that the judge can control that for everybody. So that is different than the courtroom where people can start to talk over, or you need to say something or interrupt. The judge has a little more control over this than before. That probably can be very helpful to your client. Sometimes your client starts to talk. My judge here in Far West Texas has got a really good pattern when a client in court has started to talk. He interrupts them very quickly, tells them to turn and talk to their attorney. We already have that pattern set up. That translates very easily over into Zoom, where the judge can control that. If your client is not very used to using a program like Zoom, how to participate in a courtroom, they're more visible to a lot of people. Because their video will be on the screen, and the hearing may be live streamed, there may be people seeing it, where before you're standing at the bench and maybe the volume is low and maybe their behavior is not as obvious to people who are watching the proceedings, or there's a lot going on. When you're in a Zoom hearing, this is the only thing that's happening. If they pick their nose or they start to get angry, that is going to be visible to everybody, and you're going to want to talk to them about what that means. Talking to an attorney, and this is another reason to do a dry run with your client, especially if it's going to be a more complicated hearing. Your client can talk to you through the chat function, as well as you can request a breakout room. Now, there's the real problem with the chat function. The chat function can have a default to having the chat go to everybody in the room, as if the client was standing in the middle of the courthouse or courtroom and just spoke out loud what he or she wanted to say to you. It's really important that if they want to say something confidential to you, that they pick the function on chat where they can limit it just to you. Now, one useful feature of the chat function is that you can't talk to 4 people on it. You can either talk to the whole group or to one person. But I was actually in a meeting yesterday with Kathleen and Jeff from TIDC, and with David Slayton, and with Stacy, who's running our slides. And I sent a chat message to Kathleen thinking it was to Kathleen, and then I didn't check, and it went entirely to the group. And it was not anything big, it was innocuous, but it was, as soon as I sent it, I saw it, and that is easy to happen. And we all know how easy it is for our clients to say the wrong thing at the wrong time. Finally, talk about dress. I know this is a constant struggle with many of our clients to talk to them about what to wear in a hearing. They need to dress similarly appropriately for a Zoom hearing, the same way that you're wearing suit or professional clothing for a Zoom hearing, the same way that I'm wearing a suit today. Your clients need to dress appropriately. So I had a hearing on Tuesday. I called my client to make sure he was ready at 8:50 for the 9 o'clock hearing. Because he was doing it from Zoom, he was still asleep when I called him. I think that he just put a t-shirt on. I've had the conversation with dress about him, but it certainly helped emphasize for me the focus I need to give to that, because it becomes important that we all look professional and that our clients also take it seriously and treat it professionally. Otherwise, their behavior may mirror the clothing that they're wearing. One practice note as well, where I am, when the hearing is over, the judge will usually leave the meeting room and then leave it for us to exit the meeting. Your client is on the meeting with you, or the hearing. And I've also made this mistake where at the end of the hearing, we're done. I tell my client goodbye and I leave the meeting. And I left the client on the line or on the meeting with the prosecutor who stayed on. Now, I have a good prosecutor who did not misuse that situation. My client didn't say anything and didn't offer anything, did not try and engage. But it was a real lesson to me that at the end of the hearing, be aware. It's something that you're not as aware that you're doing already in the courtroom, in the physical courtroom, but at your visual courtroom or virtual courtroom, make sure that you instruct your client to leave the meeting and watch them leave and verify they've left before you leave. Otherwise, you do have the risk of leaving them alone with the prosecutor on the hearing. And I want to talk about that security real quick, issue that David talked about. Because I'm going to talk about Skype next. Zoom was not designed for the kinds of things that is being used now. It was designed for low-level, low-risk meetings, group meetings. It was not built as a platform with the security levels built in that are now being demanded of it. And that program is needing to be overlaid onto the program that exists. It is set up to do basic security through a visual private network. And so it's difficult. And I think Zoom is going through a lot of growing pains. It's trying to react to and respond to the problems that are coming up. It's not perfect. But with one person I consulted in the intelligence and security community told me that in that field, they talk about there being, there's an adage that security often comes at the expense of functionality. Zoom is very functional. There are a lot of bells and whistles and things that make these court proceedings useful, possible for us, but they come at the expense of some of the security. They're trying to respond to that, but it's not there yet. And we just have to make the choices and know that we have to react to what's happening and see what can happen next. If I can go on to the next slide. I also want to mention one thing about open courts. That's my courtroom in Jeff Davis County. I'm going to talk a little bit later about some problems with open courts, but right now the way my courts are doing it is the proceedings are either being streamed live on Facebook Live or on YouTube. Those do raise some problems, and I will address those in the next section. At this point, that is where people are going to be able to see those things. Whether or not you want people to be seeing your proceeding is a different issue, but at this point, that's how it's happening out here. We can move on. We use, for my office, we got a grant from TIDC 2 years ago to put in video conferencing equipment in our jails. So for 2 years, we've been meeting with clients in our jails over a government license through Skype. Now, a government license through Skype has 256-bit encryption. It is a very secure line. We own the equipment. I am a government agency through the county, but my office owns the equipment. The jail does not own the equipment. Securus does not own the equipment. And so the Skype license is owned by my office. There's a license for that computer and for mine. That kind of license has the encryption. It was built that way to meet government security requirements. Up to secret level communications are approved by the US government to use on a Skype government license. That kind of encryption is not available on a business license. A government license is only available for government agencies. As a private practitioner or a nonprofit, you can usually get a business license. That level of encryption is lower. On the government license, law enforcement generally cannot get into that call. On a business license, law enforcement can access it if they know what they're doing and have the desire to do so. So that's just be aware, those of you in private practice, that the business license may not be as secure. But again, security comes at the expense of functionality. The Skype system is not used for our hearings because the functionality is low. It's in general a fairly basic system, but its security is fairly high. And so be aware of that. One of the things that we've been struggling with and trying to figure out is electronic signatures. I've decided to use Docusign, mostly instead of Adobe Acrobat. I've decided to use Docusign because it is more user-friendly. It is easy for me to indicate where somebody should sign, be able to be on the line with them and walk them through where to sign. Adobe Acrobat is just a little more difficult. That's just been my experience, and you might try both and see. Adobe Acrobat does have a free version that allows for electronic signatures, and Docusign does cost money. If I can move on to the next. This is the rule for evidence submission in my courts. Now I'm going to talk about what I'm willing to do and not at this point, what I'm going to object to in a little bit, but this is an instruction that's been given out by my district court. The full set of instructions from my district court are available, and I've given them to Jeff Burkhart, and he can make them available to y'all separately from this presentation. And I think that he'll do that through the chat function, maybe. If I can move on. And lastly, immigration consultations and other professional consultations. In general, we've been doing professional consultations for immigration for about 2 years through my Padilla. It is so much better in my mind than just calling a colleague and getting advice. We get documentation that we did it. We get documentation of outcomes. Julie Wimmer is going to be presenting on this in 2 weeks. She is a superstar. I really encourage y'all to tune in for that one because you're going to learn a lot. And she is one of my heroes. So please, please come back in 2 weeks and listen to Julie. I can talk about some problems that we've had. Confidentiality. Jeff, if I can have maybe about 5 more minutes.
Go for it.
Confidentiality, your clients may not mean the same thing as you do when you say they need to have a confidential space to talk to you virtually. Make sure that you're clear to talk to them about being alone in a room and what that means, and making sure that alone means alone. I've already talked about access to technology in general. I've got one, if we could talk about an investigation and supportive services. My office has an investigator and a social worker. We've got our clients are all over the country and over a huge geographic area here locally. We have done a lot of work in being able to do a good amount of our work remotely. If you've got questions, you're welcome to contact me and we can give you some advice on how to do that. Open courts live stream, I want to mention the problem, and the main problem that I have there is that often they are recorded, and when you get to a point in a case where you might want an expunction, whether you've done an abarra plea, which is a plea where you've got an agreement to expunge if they successfully complete probation, or you end up with a dismissal or end up with an acquittal. YouTube and Facebook are private companies and they may not honor your expunction order. That's a concern I have. I'm not sure that we've really thought through what that means. You need to check and make sure, are your proceedings being recorded or not recorded, and raise that kind of issue if it's necessary. And I think the citation I've got here, I call it an abarra plea. That's the plea that you can do where at the end of probation, if the state agrees when you enter the plea, that you can get an expunction at the end of the case. If the client successfully completes probation, the client can get an expunction even though it was a plea. And lastly, in this section, I want to talk about the thing that is an ongoing headache for all of us, and that is getting your prosecutor to respond. So much of my work over my career has been prosecutor not responding to emails, prosecutor not setting up meetings, prosecutor not doing phone calls, getting to the courtroom, finally getting them cornered, getting an offer, getting the right kind of offer because they're there and my client is there. And now doing it remotely, all that urgency is gone. One of my prosecutors I'm working with right now has been super responsive, and one of them is slow as molasses. And I don't know. We're going to have to figure out a way to corner prosecutors and really create the urgency. And for some of us, we've often taken the position that cases moving slowly is the best for our client. That may not be true. Putting the heat under your prosecutor by forcing hearings may be the way to get them to actually move on your cases. And just be aware that is the main drawback that I've seen this whole thing, is that it takes the urgency out from the prosecutor. I'm just going to mention here very quickly, and then I'll finish up the problems at the limits, the things that I think are the outer limits of what we're able to do. Anything subject to the Confrontation Clause for me right now is objection, is until I get to the Court of Criminal Appeals and the US Supreme Court to say that something that is subject to Confrontation Clause can be done by video or virtual hearing, I'm going to be objecting to. I don't know, and this came up last week with Professor Lawrence, I don't know what I'm going to do with motion to revoke hearings. The rights are not as strong for motion to revoke hearings as they are for other kinds of hearings. And I'm not sure right now how I'm going to resolve that or what position I'm going to take. I want to mention witnesses. The problem with the Confrontation Clause and virtual hearings in any kind of witness-based hearing is that you cannot see or control what the witness is doing. You have no way of policing the rule of witnesses. You don't know if the witness is off the screen refreshing their memory improperly. You don't know if somebody is by email or in the room coaching them or telling them what to do. That is my biggest fear for this. And so there's so many of the hearings that we can do that our clients need. docket calls and other motions to quash and certain kinds of suppression hearings. But with witnesses, that is my real fear, and that's where I'm going to be policing harder. And lastly, I just want to mention speedy trial in the time of social distancing. As David mentioned, there is no provision right now for speedy trials to happen virtually, or for trials to happen virtually. I have clients who are in jail, one who's been in jail for a year on an allegation of a sex crime. We were getting ready for trial as this whole stuff started, and we don't know how that's going to happen. I don't know how the law is going to develop on that and how my response is, because we can't agree to have a jury trial on a sex case with jurors not there or with witnesses being able to appear remotely. And so that's just to flag for yourself, what does that mean for you and how are we going to navigate that? I don't know. And thanks much, Jeff.
Thank you, James. Appreciate it. Thank you, David. We have about 200 people on the line, and we have had dozens of questions. And so we're going to try to get through as many as we possibly can. But David and James, if you have some thoughts on this too, one of the ones that came up just repeatedly is, if you're speaking to your client via chat, or if you're speaking to your client in a breakout session, how do you know that a judge isn't able to listen in on that the prosecutor can't listen in? How do you know that there's no transcript of that that can be viewed later?
Well,
so, go ahead, David.
I was just going to say, I would encourage you all to go do the research for yourself, but let me tell you what it says. And you can even test it out. I'd encourage you to talk to either do it yourself or talk to a judge and get them to test it with you. But let me just tell you what the functionality is. If you're in a breakout room, yes, the host, who's usually the judge, maybe the court staff, the host can actually go join your breakout room. When they join your breakout room, you're going to see them appear. They can't magically appear in your room without you knowing. You will know they're there. So obviously you should be aware of that. Just like as James was saying, if the judge were to walk into the witness room outside the courtroom, you would see them appear. You're going to see them appear the same way. Even if they appear without video, it's going to look like this. So you're going to see someone show up in your room, and you'll even see the list of participants that'll show that they're in there. So that's number one. Number two, go do the research, like I said, and test it. But the Zoom breakout rooms, which is what most judges are using for this, cannot be recorded, cannot be streamed. So the functionality is not possible to do that. But like I said, if you don't trust me, go try it yourself. Lastly, what we've told, obviously we would love for you all to use the breakout rooms, but you don't have to. You could always say, Judge, we'll be right back. I'm going to go call my client. You could always use the old-fashioned technology to do that. I will tell you that you should look and see and test out what the technology does, but I can just tell you, you can go Google, can Zoom breakout rooms be recorded? Is there a transcript of Zoom breakout rooms? You'll find the answer is it's not possible to do that.
And I have done runs with my judge where we have done both sides. And I've been in the main room when he set up breakout rooms from other people. I have been in a breakout room. I feel right now that the privacy is very similar to what I would experience in a courthouse. And it is true anytime. And I've used this also Zoom for, my sister has dragged me into a trivia game night. And, you know, the stakes are very high among trivia people. And anytime somebody shows up in the breakout room, you get an indication right away.
Thanks, James. Yeah, thanks, David. And we have a link in the chat box that Kathleen Casey Gomez put there about breakout rooms. So if you're unfamiliar with how to use those, there's a guide that you'll find in there. And then David and James, another question that just came up repeatedly, a lot of questions about the public viewing of this. And do you have any thoughts on the live streaming of this, whether the public should be, you know, I think that the Zoom chat has up to 500 participants. Should the public be going to Zoom? Should they be going to YouTube? Where do they find the YouTube links for it?
Yeah, so Judge Ferguson described this as best as I could have described it, which is the people that are in the Zoom room should be the people that would be allowed in the well of the courtroom. The participants in the court proceeding are the ones who are allowed in the Zoom meeting. That is our recommendation, and I think that's what most judges are doing. Most judges, our advice to them, and I think what most judges are doing, is then streaming the proceedings live through YouTube, through the Zoom app to YouTube. So that provides a direct way for the public to look. So if a family member or a friend or someone who would not be in the well but behind the bar wants to observe the court proceedings, you should make sure they have a link to the YouTube channel. On our website, txcourts.gov, there's a YouTube channel directory where you can see every judge's YouTube channel that's provided it to me. They are required to provide public notice of that. So either we have it or they should have it posted somewhere. Get a copy of that. You should just be able to click watch, and if they're live, it's there. With regard to the information being available later, I thought James's point was good. Our advice to all judges has been that they should delete the YouTube stream as soon as the proceeding is over, so that it's deleted, so it's not out there for public to use in some other way. Obviously, the whole point of the YouTube is to provide the public access, but not to be the permanent record or to keep it. So it should be recorded afterwards. So that's basically how that's being used. And I do apologize to everyone. I've got another webinar that starts in 4 minutes. So I'm going to hop off, but I'm confident Jeff and Kathleen and James can answer any other questions. But happy to help. If there's other questions, feel free to reach out to us anytime. Thanks very much.
Great. Thank you, David. Appreciate it. James, do you have any additional thoughts on that with YouTube and streaming?
I'll just say that it turns out I'm used to, when I walk in the courtroom, sort of turning and glancing through the room and seeing who's there. You don't get to do that anymore in a virtual hearing. So you don't know who's watching. Turns out that David Slayton was on one of my hearings earlier this week, and I didn't know. Thankfully, I think I acted appropriately, but just be aware that there are people that you can't see that are watching. The part about the recording that was of concern to me separately is that you don't have control over what an end user is doing either. And so in the courtroom, there are strong rules about people not making recordings and not taking photographs. In a virtual hearing that somebody's watching through a live stream, you don't have control about what they're doing with that at their end of the computer. It is something to be aware of. I don't know what the answer to it is right now, but it is something that even if it gets deleted, somebody else can have recorded it, stream it, or put it on YouTube on their own. That is just one of the things that are at the boundaries of what we're dealing with right now.
And Jeff, if I could also add, this is Kathleen. It also might be useful to let the judge know who's watching online. To James's point, who's in the courtroom can sometimes change the dynamic. So if there is family there or people there to support your client, that's not going to be visible in the same way that it is in a physical courtroom. So letting the judge know, you know, my client's mother and all their family are actually watching this hearing, might be something you want to consider, so that the judge is aware of who is there to support and be there for your client, because they can't be in the Zoom room.
Yeah, thanks, Kathleen. And then either Kathleen or Stacy, if you wouldn't mind, David had mentioned the link to all the YouTube channels that's on OCA. If it would be possible to maybe share that in the chat box so everybody has a link to that. James, one of the things that's come up repeatedly too in the Q&A, questions that deal with poverty or equal protection issues, either clients or witnesses, anybody else who maybe doesn't have access to a device. Maybe they don't have a cell phone, or maybe they don't have broadband internet where they're at. Any thoughts on the access issues?
This is tough. I think that we've been having some regular chief public defender meetings, both in Texas and around the country over Zoom since this all started. I think there's been some talk about trying to set up systems where people, offices can make access available if your clients are elsewhere. I don't know that we have an answer for that yet, and I think there can be barriers. I think that we are not talking about huge numbers of our clients, but we are talking about significant numbers of our clients. And for a hearing, for example, I don't think that going to the open room in a public library really is going to satisfy what we need to do. I can tell you that right now, as I said, in my jails, we have the computers where we have the Skype set up for our video conferencing. I have also gone and set up the Zoom on those jail computers. Those are in generally secure rooms that I've been using for 2 years and know how to navigate. We're in conversations with our sheriffs in those counties as to whether they can allow participants who live locally, who need access and don't have access, to be able to go to the jail and use our already existing hardware. I don't know that there are good answers right now for the hard questions. That is going to be in 6 months. We're going to know a lot more as we struggle through this and try and figure out piecemeal. But at this point, I'm just trying to do the best I can, really.
Gotcha. And then we actually have the link. I think Kathleen's already put the link to the YouTube channels in the chat box. If you don't have access to that or haven't looked at that before, I really recommend doing that. You know, I think there are somewhere around 1,000 YouTube channels that are already up right now, and definitely take a look and just peek in on some of the proceedings across the state. I think it's helpful just to watch and see how other people are handling these proceedings. James, one of the other questions that come up again and again is who should be the host on these? Is it the judge? Is it the court clerk? Somebody even asked, you know, could one of the parties be a host to this?
The judge should normally be the host, just like the judge is the host in the courtroom, in the physical courtroom. And I think both for the proceedings to move cleanly and smoothly, as well as to sort of respect the system and the way the system is supposed to work, it's the judge's courtroom. And the judge is in charge, and the judge should control who comes and who goes. For you as a practitioner, there is a free Zoom account, but if you want to be able to do things like create the breakout rooms and do that for your own purposes, you need to get a paid service account. But I think the judge or the court coordinator should, for any kind of official court proceeding, should always be the host. Otherwise, we're going to cause lots of problems. And I think it also disrupts the way the judicial system is supposed to work.
And James, we're at the top of the hour, so I want to make sure we be respectful of folks' time. So if anybody has to get going, that's fine. But we have a lot more questions, and we still have close to 200 people on the line. Do you have a few more minutes so you could stick around and answer some questions?
All you need me, Jeff.
Great. Thanks, James. Appreciate it. One of the questions that came up again was, and this is actually more of a practitioner kind of question. How do you own, you know, we talk about being in a courtroom and owning your space, right? How do you own your space during argument virtually?
That is a really good question, because I think the judge has a lot more control over me now than he did before. Probably that pleases Judge Ferguson a lot, but it is harder. The judge has control over who can speak. And a lot of what we do in the courtroom, I think, is physical theater when we're in a physical courtroom. It's how you approach the bench. It's how you're talking to your client. It's how you approach the prosecutor. And doing that virtually is very different. I don't know, actually. It's going to be part of the great experiment of this.
Kathleen, your thoughts?
Yeah, just a couple. I think it's going to be the great challenge is figuring out how to, as James said, translate what we love about practicing law and being trial lawyers to this space that, for me at least, feels very constraining. You also can't do things like see the reactions of multiple people at one time. It's so much more difficult to do that. The one thing that I would suggest everyone do is really invest in making sure you look as good as you can on camera. And I don't mean like getting some plastic surgery or learning how to contour, though that perhaps that might be useful, but really focusing on making sure your image is clear and that you can be heard. And that's extremely important if you're in an echoey space. You know, it might be useful to consider moving to a space where you're heard more clearly, and also to make sure that you have good lighting. These are things we haven't really had to consider. I talked about them a little bit in my original webinar, but now that we're getting a couple more weeks in, I'm seeing more and more people think about those things, and I'm actually better able to understand and get the message when I can more clearly hear and see someone. And so looking to the techniques of television and film, as crazy as that sounds, is actually a direction we're going to have to look.
Yeah. And if you have questions about the virtual backgrounds, about lighting, the use of Zoom, definitely check out Kathleen's webinar. We have a link to it in the chat box, and it's a really good place to start. Thank you, Kathleen. James, you know, can judges silence you with the mute button? Can they kind of take away your voice as an attorney in a way?
Yes. Now, That's the short answer. That's the easy answer. The question is really going to be your judge. What is your judge's normal way of proceeding? How does your judge consider what etiquette is and what the judge's role is in the courtroom? And so there's some judges you trust more and know that they're going to do things correctly, and there are some judges that maybe you don't trust as much. It's not something that I have a different kind of relationship with the judges that I practice in front of. It's not something that I've really been concerned about from my end. But they do have the power on Zoom as the meeting coordinator to mute and unmute participants. As I said earlier, that can be a benefit to you when your client starts to speak out of turn or say things that they're not supposed to say. But it is something that's within the meeting host, which is usually the judge's capability. I will also note something I didn't say earlier that is closely related to that topic is that I know there are some places that I have practiced, not where I currently practice, where you're not always certain if the court reporter is taking down what is happening. And I know some of us have gotten used to or gotten in the habit of looking to see if the court reporter is actually typing to make sure that we're on the record. You can't see that here. And so it is something to be aware of, is that you also cannot see what's happening with the recording.
Yeah, thanks, James. A couple more questions, then I think we'll call it a day. We have many more questions that unfortunately we're not going to have time to get to, but you're welcome to follow up with us. We'll try to get those questions to our speakers and have them get back to you. Have you had any problems with delays in transmission? So for instance, the timing of an objection, is that been an issue? You want to make sure that, of course, those objections are on the record for appellate purposes. Any issues there that you've seen?
I have. One of the interesting things is that our court coordinator is working from home right now as well, and where she lives, there's only internet connection through satellite link, and her speeds are very, very slow. And so when she talks, we're usually on a 5 or 6 second delay. Now, those who have been participating in the hearings I've had are on stronger connections, but you know, with everybody on Zoom and doing video conferencing right now, things are spotty, and those do happen. And I think that it is something to be aware of as you're having a hearing, is maybe more so than when you're in the live courtroom, to be aware of what other people are seeing. Maybe their movement on the screen is not matching what you're hearing. So there might be a delay between those two. And so you're just gonna have to be more aware. And it is just one of the technical problems. But it's not been insurmountable.
Yeah. And then we had a couple questions pop up about the links that are in the chat box. You may have to just copy and paste those in your web browser. It's, you know, for some reason in Zoom it's not showing up as a live link that you can just click through to. So if you're having trouble with that, let me or Kathleen know, but you should be able to just copy and paste that in your web browser.
It looks actually, Jeff, it looks like we're not able to copy from Zoom, from the Zoom chat. Right? It's disabled. So we'll send out the links in the follow-up when we send out the materials.
All right. Well, thanks, Kathleen. Sorry about that, everyone. Yeah, Zoom's not allowing us just to put those links directly in there so you can copy it. We'll send that out afterwards. You have the links to the past webinars. You have the links to the YouTube page for OCA and all that. We'll make sure you get that. James, I'm going to do maybe one or two final questions. Can courts charge defendants or attorneys to access court proceedings? A specific question came up about there's a service called Court Call. And I think Court Call allows folks to, I think this has been around for a long time, but usually used on the civil side, that courts can allow folks to call in as participants. And usually this has been used when attorneys or defendants are in a totally different town, but often there's been a charge for using that. Do you know if courts are allowed to charge for attorneys or defendants to use these, to access court proceedings?
So this is what I know. As David said, the Texas courts have set up through Zoom. There is a free app. If you are not the meeting organizer, you do not need anything more than the free app. You only need a paid account with Zoom if you're going to be a meeting organizer and then going to have meetings over a certain length of time or with lots of participants or lots of meetings in a month. But if you're just a participant, even as an attorney, you do not need a paid account. Skype that I've been using for my client communications does have a monthly fee. But I think that when we're using government licenses, those are paid through my office. If you're using a business license to a personal license, the personal license is also free, I believe. So I think that court administration has done a pretty good job of at least decreasing the number of financial barriers as much as possible to being able to participate virtually.
Yeah. And there should be plenty of, I mean, I think OCA has 3,000 Zoom channels that are available. There should be plenty of Zoom channels available for any judge who wants to use it, and those are free for the counties. It's paid for by OCA. It's free to use as a defense attorney. So yeah, absolutely, people have access to that. But related to this, there was another question. You know, are courts allowed to conduct a hearing via another software? Does it have to be Zoom? Could it be Skype? Could it be WebEx or GoToMeeting, something like that?
I wish David were still on. I don't know. I just know that out here we are just using Zoom, and that's the only one that I've seen from any of the orders or instructions from OCA.
Yeah, and I know for the only thing I would have to add to that, we know in Dallas that folks are using, I think it was WebEx for some proceedings. So we know that folks are using other software out there. I haven't heard of anybody being charged to use that, except for the one question we had just about the use of court call and charges for that. So outside of that, I haven't heard of that happening. If it is, if folks are being asked to pay money to access proceedings, please let us know. We'd love for that to be on our radar and to talk more about it. James, thank you so much for being here today. Thank you for David for being a part of this. I'm sorry that we didn't get to all the questions. We're already, I think we've gone about close to 15 minutes over, but we really appreciate y'all's time and all the questions and answers. We're still, I mean, this is very new, and we're still learning stuff every day on this. If you all have thoughts on future webinars, that would be helpful. If you have additional questions that we didn't get to, I'm gonna go ahead and put my email address in the chat box so you can reach out to me. Kathleen Casey Gomez already has her email in the chat box right now. Mine, again, I'll add it, but it's gburkhart, GBURKHART, @tidc.texas.gov. So any follow-up questions you have, please let me know. TCDLA is going to reach out to you all about the CLE, and they'll follow up with you on that. And thank you again for being here. Our next webinar is going to be next Thursday, again at noon. That'll be with Grant Shiner. So he'll be talking about ways to use the online courts in practice and other kind of practice tools for attorneys. The week after that, I believe we have Julie Wimmer talking about Padilla and the age of online courts. So thanks again for joining us. Looking forward to seeing you all soon. Thanks. Bye.
Bye.